Thank you, Mr. Fagan. Good evening, everyone. With the power vested in me as chairperson, I call this regular meeting of the West Orange Zoning Board of Adjustment to order. Today is December 18th, 2025. It is 8 p.m. and this meeting is being conducted virtually utilizing the Zoom platform. Notice of this meeting was given to the Township Clerk, the West Orange Chronicle, and the Star Ledger, posted on the Township Bulletin Board, all in accordance with the Senator Byron M. Baer Open Public Meetings Act. Kindly rise as we pledge allegiance to the flag. I pledge allegiance to the flag
of the
United States of
America, and to the
republic
republic
for which it
which
stands, one nation, under God,
indivisible,
with
with
liberty
liberty
and justice
justice for all.
for all. Please be seated. Mr. Fisher, Alex Fisher, Legal Counsel, kindly read the opening statement.
Thank you, Mr. Chairman. The Zoning Board of Adjustment is a quasi-judicial body. It hears evidence from sworn witnesses and makes decisions as would a court of law. The applicants are here because the projects they propose do not meet the requirements of the West Orange zoning code, or they have been denied permits by the building inspector. We are their first avenue of appeal. Board members have a twofold responsibility. First, to see that the applicant is treated as fairly as possible, since no zoning code can foresee all possible inequities. And second, to protect the welfare of the community as a whole, which is the basic purpose of municipal zoning. Our procedures are simple. The applicant presents his case, objectors then present their case. Citizens in the audience are then given an opportunity to speak both for or against an application. We expect the conduct of these proceedings to be dignified and orderly so that all parties may obtain a fair and impartial hearing. As our proceedings are public, so is our decision-making, which usually takes place the same evening. Because appeals from decisions of the board can be made to the courts and in some cases to the Township Council solely on the basis of the record before this body, and since the rules of evidence and case law are technical, we would like to advise all persons of their right to legal counsel in these proceedings, and we, the board, will consider an adjournment to anyone who wishes additional time to obtain counsel.
Thank you so much, Mr. Fisher. Ms. Chandler, call the roll, please.
Okay, Mr. Barbie,
Excuse absence.
Dr. Benzie,
Present.
Mr. Cohen,
Here.
Mr. Dannemiller,
Here.
Mr. DeBovie,
Here.
Ms. Miller,
Present.
Mr. Schwarzbaum,
Here.
Mr. Scott,
Present.
Mr. Sussman,
Here.
Mrs. Weiss.
Excused absence. Thank you, Ms. Chandler. Mr. Fisher, I count a quorum. Do you agree?
I agree.
The meeting may proceed now that we have identified a quorum. Announcements of future meetings. Regular meetings are scheduled for January 15, 2026 and February 19, 2026. Those meetings are scheduled to be conducted virtually using the Zoom platform commencing at 8 p.m. Mr. Fisher, would you be kind enough to swear in our professionals? I see Ms. Carballo is here, Mr. Dockney, and Mr. McNeil.
Right. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, you're all sworn in.
Thank you. Thank you all. You've received updated minutes from November 20, 2025. Does anybody have any further suggested revisions or comments? Seeing none, I will move adoption of the November 2025 minutes. Is there a second?
Second.
Thank you, Ms. Miller.
You're welcome.
Seconded by Ms. Miller. All in favor, say aye. Aye. Any
Aye.
opposed, say nay. Carried, all to none. Before I get into the applications that we're going to hear, and the first application to be heard will be Neil at 13 Lowell Avenue, followed by Public Service Electric and Gas, and then followed by Waystone. Also on the agenda are two matters which are here for scheduling purposes. Counsel here for Montclair Stables.
Yes, Chairman, Joseph Wenzel.
This is application ZB 25-02, property at 12-22 Woodland Avenue. We need to provide a date for you to present evidence and to move your application forward. We are fairly booked on January 15th. How do you look for February 19th?
Chairman, if you give me 1 second.
Take a whole minute.
Chairman, I am loath to not take something that's offered. So I'm going to ask if the board has availability on the February 19th date that we be placed on that, understanding that you probably will have other matters. If there are any updates, and I do expect to have some updates to our plans, those will be submitted well in advance to the through Ms. Chandler's office, and we will provide that.
Any revisions are required no later than February 9th, 10 days in advance.
Agreed, Chairman.
That gives you plenty of time. Okay, application for Montclair Stables. I just put the ZB number on it. ZB 25-02 will be held on February 19, 2025. No further notice will be provided. This constitutes your notice. If you have an interest in the Montclair Stables application, please be here on February 19th, 2025. And thank you, Mr. Wenzel.
Thank you, Chairman. Have a great night and happy holidays to everybody.
Thank you for those kind words. Next is MPB Realty. Application ZB 22-13. And this is a request for a special meeting. The council, your appearance for the record, please.
Mr. Chairman, pardon the interruption. I have a hand raised in the audience of a Danielle Kinback. Is she relevant to this proceeding?
I believe so.
Okay, I'll bring her in right now. Okay, she will be joining us as a panelist.
Did you bring Mr. Turtletop in?
He is in the audience, and I am prepared to bring him in at the appropriate time, Mr. Chairman.
You can bring him in now. That's okay. Let me go back to MPB, council.
Good evening, Chairman and members of the board. Danielle Kimback from the law firm of Prime Tuvell Maselli on behalf of MPB Realty, application ZB-22-13.
Welcome back, Ms. Kinback.
Thank you.
I haven't polled the members of the board yet, but would you prefer January 22nd or 29th for a special meeting?
If the board can make January 22nd work, that would be our preference.
Board here this evening who has a conflict for January 22nd? January 22nd. Okay, then I will schedule a special meeting for the MPB Realty application ZB 22-13 for January 22nd. This is notice to all interested parties that this matter will be heard on January 22nd at a special meeting. No further notice is required. Thank you, Ms. Kinback. Please report back to Mr. Wine and Mr. Tuvell and send my regards.
Thank you. And can you also just place the time and location, or that the Zoom link will be available on the website on the record?
It's website. It'll be published on the agenda for the for a meeting on January 22nd. The meeting will start at 8 p.m. as always, and it's on the Zoom.
Thank you.
You are welcome. Okay, let's get on with the rest of our applications then. The first application to be heard is ZB 25-06. Ms. Neal for property at 13 Lowell Avenue. Is the applicant present?
I am.
Are you represented by counsel?
I have John Ginocchio, our architect.
Place your appearance on the record then.
I'm sorry, I didn't hear that.
Let
Mr.
me
Ginocchio?
swear you in, both of you in first. Please raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, you're both sworn.
Thank you. Ms. Neal or Mr. Ginocchio, please proceed with your application.
Go ahead, John.
Okay, I would like to share my screen if I could.
Please
Um,
do.
If it's possible, I have also a image from Google of the premises. If I can share that first. I know it's not an exhibit, but I just wondered if that was okay.
I don't understand what you mean by it's not an exhibit. Was it submitted
It's
with
not,
the
it,
application?
it wasn't submitted. I just wanted to start by sharing, if everyone can see the property that I'm sharing now. This is a Google map. You can see this on Google Map. The proposal is for a 175 square foot open air porch addition to the principal structure situated at 13 Lowell Avenue. And as part of that application, there are two primary sheets. The first is A100.
Just 1 second, Mr. Ginocchio. Let's go back to the photo.
Sure.
The photo, it looks like it has a ghost on the front lawn and an orange something or other, maybe a pumpkin.
So this is a Google,
I'm sorry, Mr. Ginocchio, when I was talking, please let me finish. That photograph is marked as A1 for identification. You can proceed with the photograph or your next exhibit, Mr. Ginocchio.
Thank you, sir. Next exhibit is the A100 sheet, which is included as part of this application. It features the primary front elevation, which shows the extent of the new porch.
What's the date on that drawing, please?
The date on this drawing, it's the most recent one. This is dated 8/4/25.
Okay, no need to give it an exhibit number because it's part of your submission package. Please continue.
Okay, so the proposal is to create a front porch for our clients so that they can enjoy their front yard. The front yard setback in this zone district is 30 feet, and this front porch would project to a setback of 25.66 feet. So we're looking to get relief for 4.33 feet to allow them to have this front porch. We have the zoning information also on this sheet. And then also included with the application, I want to share the next exhibit, which is the A200 sheet, which shows the side elevation with everything.
Date of the drawing, please.
The date of this drawing is 8/4/25, like the A100 sheet.
Thank you.
You're welcome. So it shows the side elevation of this proposed porch, and the balance of the house is a hatched pattern. This particular sheet also shows some construction details of how that porch would be made. The third exhibit I think is kind of interesting to see, is also part of the original submission. This has got a markup showing the line of the proposed porch on a survey by Richard J. Hingos that is dated 5/25/1998.
There are some red insertions on that. Who made those additions?
These comments were made by myself.
Were there any other changes made to the survey other than the red?
No, sir.
insertion?
No, sir.
Okay.
Just for the purpose of providing clarity on this exhibit is where that porch would reside.
Continue.
One point I'd like to make is that the setback currently for the existing stoop, which allows access to their house, is 26.20 feet from the front. I mean, 26.19 feet from the front property line. So where the step up to a flat spot so they can enter their home is currently 26.19 feet. What this proposal does is it gives them a place to get out of the elements, a shaded structure, also a place to gather friends in their front yard, a place to receive visitors that are not necessarily ready to come into the house that they want to meet in a covered environment. Also a place to accept trick-or-treaters, if you will, accept the first exhibit, which was the Google map, where there was Halloween decorations out front. So we think this would be a improvement for the neighborhood, for the township, and it would not have any material detriment to the welfare of the community or have any hardship that we would foresee. So I think that's basically what I'd like to say.
What are the reasons you're presenting for the grant of the variance, which is quite a small amount?
Say that again?
What are the zoning bases for the grant of the variance?
So we had a written statement that I can read from some. I still don't think I understood your question. Could you say it one more time?
Okay, let me ask it a different way. Is it your testimony, sir, that this is an appropriate development of this land?
Correct. Yes, I do.
And is it your testimony, sir, that this will provide adequate light, air, and open space?
Absolutely.
And is it your testimony, sir, that this development will provide a desirable visual environment?
Yes, sir, I believe so.
That's all my questions on that subject. Please conclude. Anything further you want to offer? Mr. Ginocchio?
So I think that speaks for itself. I don't know if there are any questions that the board has. We'd be glad to answer any further questions, but
Yeah, we're going to get to that in just a moment. So that concludes your direct testimony, is that correct?
that's correct.
Okay. Members of the board, let's start with Mr. DeBovi. Any questions?
No questions from me. Thank you.
Dr. Bensby?
No questions. Thank you.
Mr. Danamella?
One small question. Thank you for your testimony. Will there be new steps added in addition to the actual porch that would be closer to the road than the setback of 25.66 feet?
Yes, sir. There would be steps that would project beyond that. You know, there would be two steps that would project 2 feet approximately further that you can see on the site plan, as
Wonderful.
well as.
Thank you. That answers my question.
Sure.
Thank you.
Thank
No
you.
further questions.
Mr. Sussman?
No questions, Mr. Chairman.
Thank you. Mr. Schwarzbaum?
No questions.
Ms. Miller?
Yes, are the trees that are in the front yard to remain?
Correct.
Okay. Thanks, that's all.
Mr. Cohen?
I'm looking at this little thing, and could it properly be called a mudroom where you hang coats and you put your your dirty boots and to enter an area before you enter the house, keep the house clean? Is that sort of what it functions as?
So I'll zoom in on that A100 sheet in the drawing number 2 to help answer your question. There is an existing foyer which has a coat closet. So that is already part of the existing house. What this new porch does is provides exterior covered open space before you enter that foyer.
Oh. Okay, that's the only question. Thank you.
Thank you. Mr. Scott?
No questions.
Thank you. Ms. Carballo, any questions?
Yes, I do. I do want you to clarify, based on your testimony, you say that is 175 square foot addition. However, if you look at your plan A100, it does show 155, I believe, in this site plan, and it also shows 155 on the first floor plan. So which square footage is it?
It's the 155. Apologies about that.
It's okay.
Thank you for that
That's the question I
clarification.
had.
Ms. Carballo. I'm sorry, anything else, Arbel?
No, that's it. That's all the question I had. Thank you.
Thank you. Mr. Dapney?
I do not have any questions at this time, Mr. Chairman.
Thank you so much. Mr. McNeil?
No questions, Mr. Chairman. Thank you.
This is the point in time where members of the public have the opportunity to ask questions of the witness. Kindly raise your hand so that you can be recognized. This is not the time to make any statements in favor of or in opposition to the application. This is simply to ask questions to Mr. Ginocchio based upon his testimony. Kindly raise your hand so that you can be recognized. Mr. Fagan, let me know what we have.
Mr. Chairman, there are no hands raised from any members of the public at this time.
Then I will close the portion of the hearing for public questioning of this particular witness. Do you have any further witnesses or testimony or evidence to present on behalf of the applicant?
No, sir, I think that's all for us.
Okay. I will now open the public hearing to members of the public with respect to testimony or evidence or both, either in favor of or in opposition to this application. Kindly raise your hand so that you can be admitted and sworn under oath. Mr. Fagan.
Mr. Chairman, once again, there are no hands raised by any members of the public at this time.
Thank you. Then I will close the public hearing aspect of this application. Does the applicant have any further comments that she would like to make? It's not that. I'm sorry, Ms. Neal.
I think we're good. I think John did a good job explaining what we're desiring to do here.
Okay. That closes the applicant's case. There is no opposition to the application. It's my pleasure to offer a motion to approve this application and to grant what is close to a de minimis variance with regard to the front yard setback to allow 25.66 feet instead of 30 feet, to 25.66 feet plus 2 steps, coming a little closer to the front yard, to the front boundary. I don't see any conditions. Does any member of the board wish to suggest a condition?
A second as is.
Thank you, Mr. Danamel. So the motion has been made and seconded. Is there any discussion? Does any member, please take your screen down, sir. No?
I'm sorry.
Stop the share screen, please. Any member of the board wish to be heard on this application, kindly raise your hand. Seeing none, then Ms. Chandler, would you kindly call the roll for a vote on this motion that I've presented?
Okay, Mr. Cohen,
Yes.
Ms. Miller,
Yes.
Mr. Schwarzbaum,
Yes, to approve.
Mr. Scott,
Yes.
Mr. Sussman,
Yes.
Mr. Dannemiller,
Yes.
Chairperson Neuer.
Yes. Mr. Fisher, please note that the findings under purposes of zoning A, C, and I are part of the basis for the positive criteria having been met. Ms. Neal, your application is approved. Please communicate with Ms. Chandler and she will explain to you what has to be done. There will be a resolution prepared by our legal counsel, which will be considered by the board at its January 15th meeting. It's not necessary for you to be here, although you are cordially invited to attend. Otherwise, you can communicate with Ms. Chandler again after January 15th, and she will let you know what happened.
Thank you very much.
Pleasure. Thank you.
Merry Christmas.
Thank you. And Happy New Year. Members of the board, at long last, we are going to have a presentation with respect to application ZB 24-06, Public Service Electric and Gas Company for property at 325 Mount Pleasant Avenue. Starting with Ms. Porter, counsel, your appearance for the record, please.
Good evening, Jennifer Porter with CSG Law on behalf of the applicant PSE&G.
And Mr. Turtletop, your appearance for the record, please.
Yes. Good evening, ladies and gentlemen of the board, Mr. Chairman, James Turtletaub from the Turtletaub Law Firm on behalf of Kevin Malonga.
Thank you both. Wait a minute. This is an application which has been before this board on August 15, 2024, September 12 and 19, 2024, October 17, 2024, December 12, 2024. On January 16, 2025, with no testimony taken. February 20, 2025, and March 20, 2025. Then the following nights were simple presentations of status reports with no testimony taken on April 17th, May 15th, July 17th, September 18th, October 16th, and November 20th, all 2025, which brings us to December 18, 2025. It is my understanding that council have something to spread upon the record with respect to this application. Take it away, Ms. Porter.
Perfect. So thank you, Mr. Chairman. We are delighted to report and make this joint statement that the parties have settled their respective issues concerning PSE&G's application. And as a result of that, certain design changes have been made to PSE&G's plans that were submitted to the board in connection with tonight's meeting. And PSE&G does intend to provide limited testimony explaining those changes from its civil design engineer. Just to summarize, those changes include the following. First, PSE&G's plans previously showed bioretention swales as part of its stormwater design. Those plans have been modified to remove those basins and to provide an underground stormwater infiltration detention system. This allows for an additional 44 trees to be preserved that were previously marked for removal. And this will be discussed in detail by PSE&G's project engineer. As I indicated, plans in a summary have been provided to the board and its consultants with this change, but we would be requesting as consideration, should the board decide to approve this application, that a condition be imposed that fully engineered plans for stormwater design be provided to the satisfaction of the board engineer. With respect to this change, we also wanted to note that PSE&G's application to this board was originally submitted back in May of 2024, as the chairman was indicating, in terms of the length of process that we've been involved in connection with our site plan and use variance review. It was submitted prior to West Orange Township's adoption of the stormwater ordinance amendments, modeling DEP's green infrastructure requirements, and therefore it is our position that this application is grandfathered from the current requirements, which are contained in Chapter 25 of the Land Use Code, Section 2529, stormwater controls with respect to the use of green infrastructure as a stormwater design measure. And so therefore no further relief would be required from this board in connection with the change to our stormwater design for this application. That is part of our proposed testimony this evening and part of our proposed agreement with the objectors in connection with this application. In addition to our stormwater design changes, we have also made other design changes in an effort to additionally save several other trees. We will be making a shift to the circulation path in order to save an additional tree, and we will be making a tweak in connection with an existing tree which was previously noted for removal that can be saved, which will be shown on our plans later by our engineer, that was previously marked for removal but is no longer impacted. In addition to that, we will be making a shift in connection with one of our manhole locations that will also result in the savings of one of the larger London planes at the site. In connection with this, we can represent that the tree removal plan that was provided to the board in connection with tonight's hearing is the same plan that forms the basis of the agreement between PSE&G and Mr. Turtletop's client, and depicts the total number of viable existing trees on the site being reduced from 136 to 89 trees. So it's a total savings of 47 additional trees. The tree removal plan remains in compliance with the new tree ordinance. And in addition, as a result of the additional trees being saved, a contribution to the tree fund would no longer be required because all of the replacement trees that are being provided, in addition to the ones being saved, satisfy the requirements of the ordinance without further contribution being necessary. At this point, I would defer to Mr. Turtletop as to any statements by him or his client or others regarding the status of their objections. And I understand that Mr. Turtletop or his client will be discussing an additional proposal concerning the replacement fence, and I defer to them in that regard.
I thank you, and I'll wait till after your testimony with respect to the replacement fence. But overall, Ms. Porter did an accurate, well-done summary of the agreement and the number of trees we were able to save here through a lot of effort on all parties to make this a plan that hopefully the board will appreciate tonight. But it is the product of a lot of work to try to figure out the best way we could save as many, especially the larger historical trees that have been part of the community for many years. And I'd like to thank the board for letting us get through all of this. But again, Ms. Porter's summary was very, very accurate as to where we're at in this.
Okay, so if the board would like, I can now proceed with our additional testimony. Before I do that, I did want to begin with a brief overview of the prior testimony in connection with this application. I would normally skip this, however, due to a number of reasons. First, the passage of time. There has not been any active testimony on this application for nearly 8 months. Second, there have been changes in terms of the board membership. And although, of course, everybody's required to read the transcripts, it's always good to refresh everyone's recollection as to kind of the basis for the application. And number three, there are new consultants to the board who may not be as familiar with the prior proceedings in connection with this. So I did prepare, like I said, an overview of some of the testimony that was provided. Again, just to begin, board members, we do greatly appreciate the board's patience in allowing the applicant and the objectors to this application the time to address and come to a mutual understanding as to how those concerns could be addressed. prior to the last 8+ months of settlement discussions and reports to the board on the status of those discussions. We held 5 hearings in which detailed testimony was provided, and the applicant provided expert and fact witness testimony from 4 individuals. Its civil engineer, its electrical engineer, its landscaped architect, and its planning expert, in addition to its project manager, regarding this critical utility infrastructure project. Again, before, or by way of background, you heard in detail previously about the application, which is for preliminary and final site plan approval and use and bulk variances that are required to replace the existing 26 kV equipment, which is nearing the end of its useful life cycle. And it's being replaced with new 26 kV equipment and associated site improvements. You previously heard that in order to power the switchgear, PSE&G needs to make sure that its connection with PSE&G's 230 to 26 kV transformers, and that there are bus systems and bus support structures that will feed the switchgear. And all of this equipment, including transformer reactors, circuit breakers, underground conduits, and duct beds, are carefully and specifically designed and placed to protect and regulate the line to make sure PSE&G is and will continue to operate at a safe and manageable voltage level and power level. So with all of the proposed improvements, PSE&G testified that it's being proactive and protective. Its primary goal, as you heard in the testimony repeatedly throughout these proceedings, is to provide safe and reliable service to its customers. And that was the primary driver for the proposed improvements that we're seeking relief from this board, each and all of which are specifically designed to make the site safer and to provide a reliable electric service to its customers, as well as to avoid service disruptions and outages to the maximum extent possible and for the shortest amount of time possible. And this ties as well into the testimony you heard about the lengthy construction process, 4.5 years, due to the construction sequencing of transferring these existing circuits to the new switchgear to maintain reliability and resiliency of the station. As you heard from the testimony, the station has operated at the site for almost 100 years, since 1928. It has always been a switching station, and the approvals sought from this board will allow it to continue to serve thousands of West Orange residents and the surrounding municipalities in that capacity. Thoughtful and careful consideration was given to existing site constraints, and that was the subject of many of the discussions with Mr. Turteltaub and his client. And the fact that the existing equipment must continue to operate while the new system is being constructed so that PSE&G can prevent outages from occurring to the maximum extent possible. You also heard that the proposed improvements trigger the need for stormwater compliance. That's a big part of tonight's new testimony because of the change in terms of the system being provided. And we've worked diligently as part of our agreement with the objectors to provide a system that not only satisfies the township's requirements, but at the same time now preserves the maximum extent of trees possible. As you also heard, the work includes realignment of the access road along Mount Pleasant and within the site to align the new equipment and to provide and better serve the utility use on the site both during and after construction. As I indicated, we're making a minor shift in that circulation path to allow for an additional preservation of a tree, which will be discussed by our engineer. Also heard in prior testimony, PSE&G is incorporating additional lightning masts that are critical to preventing lightning strikes from occurring. That will be the same size and height of the existing lightning masts that have existed at the site for years and are actually less in height than the radio microwave tower, which is 188 feet, and the H-frame, which is 73 feet. So that's part of the D6 relief. As I mentioned, in terms of the station, we are seeking the D2 variance relief that was previously testified to. You further heard a lot of testimony regarding PSE&G's replacement of the existing fence, which is in very poor and deteriorating condition. As you saw from numerous photos which were shown, it's being replaced with a new fence. As you heard in prior testimony, the main driver for the fence replacement is that the new fence meet PSE&G's height requirements for security purposes. With regard to the tree removal plan, both now and throughout the entire land use process, significant consideration has been given to the trees that were selected for approval or for removal rather, and why and whether anything can be done to preserve more. That is all the more true now as a result of the agreement that was reached in connection with this application. PSE&G gave prior testimony from its landscape architect about how they, after our initial meeting with SPRAB, went back and re-evaluated our tree protection plan and was able to result in additional tree savings at that time. In addition, we held several on-site meetings with our entire project team post our initial hearings. We had meetings with the township forester on our site to see how, what, and if anything could be done in the effort of tree preservation. And as I mentioned at the beginning, we have also, as a result of some changes to our design, been able to now save those 47 additional trees on top of what was previously done. As testified to at length, and as a result of our settlement, we are only now removing 103 trees, of which 89 are viable and the other 14 are already dead. But we are preserving more than 400 trees, and we are replacing the trees being removed with close to 750 trees total on site between existing and proposed. You heard about the fact that there were multiple site visits in connection with the issues that were raised by the board at the prior meetings. In addition, and lastly, PSE&G's planner provided substantial testimony on the relief needed and the justification for such relief, including multiple specific reasons that the board can and should approve this application, that this is an inherently beneficial use that promotes the general welfare, that reliable electricity is essential and critical to our modern way of living, that this board previously found in prior applications that the site is an inherently beneficial use and well suited for a public utility use, that there are special planning reasons advanced by this application, the specific purposes of the municipal land use law are promoted. There is a reduction in outages that advances safety from and during natural disasters, and it's the promotion of energy resources in the state. It also advances purposes in the West Orange Ordinance, giving and regulating orderly development and the provision of reliable service for almost 100 years. And it's also promoting in the public interest the utilization of land for its most appropriate use, and it advances the purposes of the ordinance by encouraging coordination of the various public and private procedures and activities shaping land development. All of the things that I have just stated have been provided in prior testimony and could be found and repeated in the transcripts from the prior proceedings. I am summarizing them again tonight for the benefit of the board. This has been a long, but I believe very terrific project, and we believe that the plan presented this evening not only meets the criteria under the ordinance and the proofs necessary for the granting of relief for this project, but that also satisfies and addresses some of the concerns that were raised throughout this process as part of our public dialogue in connection with this matter. And so with that, if the board has no questions for me regarding prior proceedings or prior testimony, I'm happy to introduce Michael Blake to give his testimony regarding the changes to the site. Mr. Chairman?
Ms. Porter, in light of all of the changes that have taken place since the submission of the application and the testimony of your planner, do you have a list of the variances that you are seeking?
Yes.
If I may impose upon you to put that into the record so we know what it is that you're seeking.
Sure.
That would
So PSE&G is seeking preliminary and final major site plan approval. In addition, PSE&G is seeking use and bulk variance relief. First, PSE&G is seeking a 40:55D2 variance for expansion of a nonconforming use. Since the table of district regulations does not list public utility buildings or structures as a permitted or conditionally permitted use. In addition, PSE&G is also seeking a 40:55-70D6 height variance for exceeding the required height by more than 10%, because the applicant is proposing to install 6 approximately 70-foot lightning masts, which measured to the adjacent finished grade, and some ancillary utility equipment, bus supports, and lightning finials that are over 35 feet. In addition, PSE&G is seeking bulk variances for the front and side yard setback, lot coverage, and the fence height requirements, which I believe the fence height limits 6 feet, and we're proposing a fence height of 8 feet with the pillars being slightly higher.
So the bulk variances are front and side yard setbacks and the height of the fence,
And lot coverage.
lot coverage. I'm sorry, I missed that one. Thank you. Please present your witness then. Oh, just so that the record is clear, you did make a statement about grandfathering with respect to the green requirements for stormwater management. That was confirmed by Mr. Hess while he was still the engineer on this project. So that is, that should be in the record. And when you talk about the replacement of trees, I believe there was a stipulation that they would be native trees.
Yes.
Okay, thank you. Again, your witness, please.
Okay, at this time, I'd like to recall Mr. Michael Blake. He had previously provided sworn testimony as our project civil engineer. He was also qualified as an expert in the field of civil engineering. I don't know if the board prefers to re-swear him because it's been some time, or if you rely on the fact that he's still sworn and under oath.
We would like him sworn. It's been
Please
forever
raise
since.
your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, you're sworn.
Thank you.
We don't have to go back through his credentials. I would just ask Mr. Blake, is your license still in full force and effect?
Yes, it is.
Has it been suspended since you were here the last time?
No, it has not.
Okay, so you continue to be recognized as an expert in the field of civil engineering.
Thank you.
Please continue, Ms. Porter.
Okay, great. Mr. Blake, if you could please walk the board through our proposed site plan / tree removal plan and explain the changes that are being made to the design of the project in comparison really to what they were previously shown in terms of what was proposed for the site. So if you could walk them through those changes, specifically focusing on the stormwater design and the resulting additional preservation of trees.
Is it showing the PDFs up there?
Yes.
Okay.
And this is the plan that was provided as part of the resubmission to the board that was made prior to this hearing?
Yes, that is correct.
Okay.
And what is the drawing designation? Is
This drawing is 792790, and it is conceptual grading and drainage plan.
and the date?
The date on it is December 8th, 2025.
Thank you.
So previously, the site contained bioretention basins that was located here on the kind of the east side of the station. Due to the with the redesign, we were able to relocate our stormwater management system by putting 2 underground basins. There's one here, and then there's another one here. Basically, the plan is to collect the stormwater from the station expansion in a shallow drainage ditch that runs along the east side of the drive path, eventually putting it into an underground pipe system that routes it to the basin. From there, the stormwater will, either infiltrate into the ground, or, as the larger storms come through, those will be routed through a pipe network and back into the existing stormwater network in Mount Pleasant Avenue. We also have a trench drain that is on the outside of the drainage swale that we have shown. And this is essentially to catch all the stormwater that's coming from the hillside. So on this drawing, the drainage kind of slopes from west to east for the station proper, and then the hillside on the from Prospect Avenue, basically the fence line slopes downhill back towards the station. In order to keep that stormwater separate from what we're routing to the basin, we collect that through a trench drain, and that is just tied directly into the same stormwater network that discharges and is routed through Mount Pleasant Avenue. From there, some additional changes. Well, first off, the detail sheets, we only provided one additional detail sheet, basically give kind of a general concept of what the stormwater basin system will look like, and then a configuration. Once we get through full design, we'll have a better understanding of exactly how it's going to be arranged, but right now we're planning to use an underground modular system to help provide it. This is an example from Old Castle. Final design will determine the vendor. Moving on to the tree removal plan. As Ms. Porter previously testified or provided in her summary, is that the tree preservation has increased. The 3 trees that she spoke specifically about was tree 4084. For clarity, I have highlighted them just so they're easier to see on the print, but it was 4084, 4135, and then the third one is this 4328. And those were the 3 that she spoke specifically about, in addition to the additional 44 trees that were saved.
And Mr. Blake, if you could just speak, the bottom 2 trees, if you could just show them the shift in terms of the manhole, I guess, point to which tree we're shifting the manhole, that one.
So tree 4135 used to have a manhole located approximately here. That manhole, it's an electrical manhole, has been shifted farther north into this pocket area. This circle right here represents an approximate location of where that manhole is. And by shifting it north, the electrical duct banks that tie into it were allowed to be adjusted. You can see it a little better on the conceptual grading plan, but this is what we're referring to. And then the other tree that was located in this area, I'll go back to this one, is the 4084, and this is the general area that we plan to put an underground detention basin. And then we've also adjusted our road. As you can see, it comes through here and it routes down. Previously, the road was mirroring basically this configuration where it curved up and back into the existing station. The plan is also to remove this existing driveway that comes through here and return it to, grass.
And Mr. Blake, PSC&G had prior discussions with the board engineer in terms of the conceptual design and layout of the proposed stormwater system?
Yes, they did. And so our plan is to continue progressing with this design. We did put in a decent amount of design and calculations to kind of make sure we had a good comfort level that this is going to work. And so the plan now is to finalize that design, work with the board engineer, submit a full package that represents this, have a lot more detail that it will address. You know, the board engineer had some preliminary comments based on this conceptual plan, and we plan to address all those comments and also include, you know, any additional details that were not included in our conceptual plan.
Great. So it's our intention, it's PSC&G's intention to comply with the comments set forth in the most recent engineering report and work on them potentially as a condition should the board decide to approve this plan.
Yes, that is correct.
Okay.
In addition, I will also say we provided a stormwater management memo that explained kind of how we were going to achieve the stormwater calcs, the green infrastructure, you know, requirements that that are part of NJAC 78. So we plan to address all those as well, not just the drawings, but also the calculations.
Calculations been submitted to the board secretary.
Yes, and the summary has been. That was
Yes.
included as part of our resubmission.
And that is the document that's on the screen right now.
Yes, the document that's on the screen was part of what was provided to the board secretary.
And it has a revision date of December 8, 2025.
Correct.
Please continue, Ms. Porter.
Mr. Blake, do you have any further comments with regard to the revised design?
One other thing that I know has come up, you know, both in previous testimony or previous board engineer review comments and this conceptual one, and that was probably a misdirection on the sidewalk. We do not plan to replace the sidewalk. The only plan would be is if we had an electrical duct bank or another utility crossing the sidewalk. If we had to, you know, saw cut through it, we would, you know, replace that in kind. But in general, the existing sidewalk, the majority of it should stay as is.
Great. I have no further questions for Mr. Blake.
Members of the board, let's start with Mr. Scott. Any questions for the witness based on the testimony he's presented? Mr. Scott?
No.
Mr. Cohen?
I have a question about the fence and the brick and the metal parts. There was historic preservation department wanted to preserve it. Was there any preservation of the existing bricks and metalwork, and could the addition to 8 feet be on top of the historic bricks and metal?
So in connection with the fence, PSC&G is replacing the existing fence. It's our understanding that Mr. Turtletop and Mr. Malanga have a proposal that they're going to present on the record this evening, but there have been significant discussions regarding the fence in connection with this project. And it involves a discussion in connection with the foundations, the pillars, and the existing fence.
I'm sorry, I don't really understand that. What there was no ability to save the historic part of the brick and the metal.
So the fence itself is an older fence. It's in very poor condition, deteriorating condition. There are portions of the fence that are actually have holes, are falling apart, have chipping paint, are bent. The existing.
I'm sorry, Ms. Porter, that wasn't the question. Mr. Turtletop's hand is up. He may want to offer something.
Perfect. That would be helpful.
Mr. Cohen, yes, that was a topic of discussion, and I was going to put it after their testimony was in. I did not want to interfere with it. I had mentioned briefly in my introduction. We do have a request to be made for a condition as part of the approval. The concerns you're raising there about the fencing. Mr. Malonga appreciates the fact that the structure itself, albeit it's a bit old, is still historic in nature. It provides character to the area, and I do have a proposal I can either put on the record now or wait till the end of PSE&G's testimony. But either way, we do want to address that, and I just didn't want to interfere with the testimony being given by PSE&G at this time.
So you'll put it on the record after Ms. Porter finishes. Mr. Cohen, you can revisit your question after Mr. Turtletop explains what will and will not be happening with respect to the brick pillars.
Okay.
As a preview, it talks about using wrought iron for. Oh, I'm sorry.
Mr. Cohen, do you have any other questions?
No, that's it. Thank you.
Okay. Thank you. Ms. Miller.
I have no questions for Mr. Blake. Thank you for your testimony.
Thank you. Mr. Schwarzbaum.
Yes. Thank you for your testimony. The swale system, has PSE&G used this on other sites?
Yes, we've used drainage swales in other substations. Both, I've designed them for stations all over the country, and we've utilized them in other PSE&G stations as well.
So is it your expert opinion that the new design will be equal to the old design in regard to drainage?
Yes, it will be. It's a smaller system because there's less. Bioretention has voids in it, or has material in it. The underground basin does not have material in it. It's like an open cavity, so it provides good volume storage, and they're very efficient. So I think it will be equally as good as the previous design.
Okay, thank you.
Thank you, Mr. Schwarzbaum. Mr. Sussman.
Thank you for your testimony. No questions, Mr. Chairman.
Thank you. Mr. Dannemiller.
No questions. Thank you.
Dr. Ben-Zvi.
Yes, thank you. I do have a couple of questions. The 47 trees that you will save, does it include the trees that Ms. Porter referred to as we're tweaking a bit to save a few more trees? Does it include these tweaks that she was referring to?
Yes. The whole reason for the redesign was to remove the bioretentions basins, because the footprint for them was so much larger that it impacted a lot more trees. By switching to an underground detention basin system, the footprint and disturbance is a lot smaller, which allows us to preserve more trees.
Okay. I read the forester's report dated December 16. He wrote, I would like to meet, and this is a quote, I would like to meet on site to see if I can save more trees on site, end quote. Was such a meeting scheduled with the forester?
We have had, the forester has actually been to the site on several occasions. I don't know if the forester is present this evening, and the forester also wrote prior memos indicating that the prior tree removal plan was consistent with the ordinance as well as this plan.
I agree with what you said. That was the first point in his
To the
memo,
extent
but
that
he
the
still
board
wrote
wants-
that in.
Right, to the extent that the board wanted to impose a condition that the forester have the opportunity to come to the site again. The forester had previously been to the site and made statements indicating that they were satisfied with the the prior plan. But we're happy to agree to that as a condition of approval, that the forester is welcome again to come to the site.
I'll just note again, this is a memo dated 2 days ago. So,
Correct.
okay.
We did see that comment as well.
Okay.
We're happy to comply with it. And I just wanted to note for the record, the forester has been to the site on several occasions.
Okay, thank you. That's all I have, Mr. Chairperson.
Thank you. Mr. DeBovi.
No questions for me. Thank you.
Mr. Blake, I'd like you to clarify something that was said by either you or Ms. Porter, and that has to do with the sidewalks. Is it your testimony, sir, that the sidewalks are intended to remain intact and not to be removed?
That is correct, unless we have a utility like a duck bank or something that has to leave the site. But it would be minimal impact. It wouldn't be tearing the whole thing out. It would just be, whatever is needed for that underground duck bank to leave the site.
And to the extent that any sidewalk is disturbed or removed in part, it'll be replaced before the project can get a certificate of occupancy? Ms.
Yes.
Porter? Okay.
And I was going to
that's
say also, because we're redoing this entrance, there's going to be some adjustment to the sidewalk there as well. So,
right, that I understand. Mr. McNeil, questions for the witness?
Yes, thank you, Mr. Chairman. Mr. Blake, thank you for your testimony. Obviously, as you saw in our letter dated December 12th, drainage comments is our primary concern with some of the revised design. I think I spoke to another engineer in your office that really just want to put on the record that you're going to be switching that underground detention basin to an infiltration basin in order to comply with both township as well as DEP regulations.
yes, that is the plan.
Okay.
Will that be shown
wor-
on the revised plans?
Sorry, I didn't hear that.
That will be shown on the revised plans, correct?
Yeah, it'll be all part of the infiltration design will all be taken into consideration in accordance with NJC 7.8 when we do the full design.
Okay, and then just one last thing on stormwater. Obviously, you'll be adding, another discussion we had was just adding MTDs to meet that water quality requirement on top of the swale, right? You
Yes.
did that. Okay.
We started investigating just this week options for MTDs and where we could put them.
Okay. All right, great. That is all I have.
Mr. McNeil, for those of us who don't have your education in engineering, please place on the record the definition of MTD.
Yes, I'm sorry. So manufactured treatment device. So DEP requires, and the township code reflects those requirements, for really water quality treatment. They meet a certain total suspended solid removal rate by having the grass swale, but they don't meet the total requirement of 80% for this total suspended solid removal rate. They will meet that by adding an additional manufactured treatment device before going into the underground system.
Succinct and understandable explanation.
Thank you. Yeah, and that's all I had for Mr. Blake.
Thank you. Ms. Caraballo, questions for the engineer?
I don't have any questions, Chairman.
Thank you. Mr. Dockney, any questions?
Yes, just a couple of questions, Mr. Chairman. Since it was just brought up about the historic nature and the fence, I want to confirm something. Is this property officially listed on any register of historic places or designated as a landmark by the township?
It wasn't listed. We did receive a report from the Historic Commission.
I'm looking through those records now, and I see there is a SHPO opinion from about 12 years ago, but I don't see that it's officially listed on any
It
registers.
was no, if you read the entire thing, it doesn't state that it was going to be listed.
Okay, just confirming that this is not officially designated as a historic landmark.
Correct.
And then second, and perhaps this was testified in one of the previous meetings, and I've skimmed over the minutes from all those meetings, but the fence, since you're proposing 8 feet where 6 feet is the max permitted,
Let's hold questions on the fence until after Mr. Turtletab makes his presentation. I'll be happy to recognize you at that time for fences.
Absolutely fine. Thank you. That was the only questions I had. Thank you.
Thank you. This is a point where I'm going to make the announcement that I'll probably have to repeat a couple of times. Members of the public, this is your opportunity to question the witness based upon the testimony he has given. While you have heard commentary about an agreement being reached between the applicant and Mr. Malanga and other people in his group, that does not bind the rest of the public. So if you are not a member of Our Green West Orange, which is part of the settlement, and you have not being represented by Mr. Turtletab, you are free to ask questions of the witness. You will also have the opportunity to present commentary either in favor or in opposition to the application at the end of the hearings. You are not bound by any settlement reached by Mr. Malanga and his attorney if you are not part of the group. In addition to that, this board has the right and the obligation to make a determination on the merits, regardless of the fact that there may be a settlement. So this is not limited only to Mr. Malanga and the applicant, but any member of the public who has questions for the witness based on his testimony, please raise your hand so that you can be recognized.
Mr. Chairperson, we do have a person whose hand is raised, but before I bring them into the meeting, can we stop the screen share so that I can place the clock on screen?
Certainly, just there you go. Thank you. Okay.
Okay, bear with me 1 second. Edie Bear, thank you for your patience. Please state your full name and address for the record. Welcome to the meeting.
Thank you. It's Edie Bear, 14 Dogwood Drive, West Orange. Mr. Blake, I just wanted to ask you about the water that you said will be directed to Mount Pleasant Avenue. I don't have any sense of how much water that is, and I wonder if you know if the stormwater system has enough capacity for however much water that is. And I'd love to be assured that that's not going to cause any flooding on Mount Pleasant Avenue.
So the way we design the system is we analyze how much stormwater's leaving the property currently, and then we make sure that our proposed design, equals that number or reduces it in accordance to the requirements that are provided in the code, which is what I kept saying is the NJAC 78. So we will not be providing any impact to the Mount Pleasant stormwater system that's currently there. I can't speak for the whole system because it's a giant system, but as far as what we're providing, we will be providing a system that should be better than what is there.
Thank you.
Anything else, Ms. Bear?
No, thank you very much.
Thank you so much. Mr. Fagan, any other hands going up?
As Mr. Chairman has indicated, any members of the public wishing to question this witness, please raise your hands at this time. Mr. Chairman, there are no other hands raised.
Thank you so much. Then we will close the public questioning aspect of the application at this time. Ms. Porter, are you now yielding the floor to Mr. Turtletab? Is that what I understand?
Yes, I am.
Okay, Jim, before you start, it's 9:14. I know you're going to take more than 15 minutes. So let's take our break now. Ms. Triolo, I'm starting to get a little bit antsy about whether we can get to you tonight. You're more than welcome to stick around. I don't know how much longer we're going to, as I told you, we can't control the timing.
Do we know how many witnesses are planned for this evening?
I don't understand the question.
No, from public service. How many witnesses they have left to call?
Well, public service doesn't have any more witnesses. Mr. Turtletop, how many witnesses are you gonna have, or are you just gonna make a presentation?
I'm going to make it'd actually be a relatively short presentation, but to go over the concerns that my client has and a request to the board to make as a condition of approval. But I don't believe it should be more than 15 minutes or so, I would think.
So, Ms. Triolo, stick around. We're gonna.
We
break
will.
at
We're
9:15.
I'm enjoying the meeting. Thank you.
9:15, please all be back by 9:25. We are in recess. Shuffles in. Waiting for Mr. Sussman and Mr. Scott. Mr. Sussman? Come on back, Mark. Okay, recess is over. Ms. Chandler, please call the roll to confirm that we have everyone back.
Of course. Mr. Cohen,
Here.
Ms. Miller,
Present.
Mr. Schwarzbaum,
Present.
Mr. Scott,
Present.
Mr. Sussman,
Here.
Mr. Dannemiller,
Here.
Dr. Benzie,
Present.
Mr. DeVoe,
Here.
Chairperson Neuer.
And I am here as well. Thank you very much.
You're welcome.
Mr. Fisher, we confirm that we have a quorum to proceed.
I can confirm.
Thank you. Okay, so when we left off, Ms. Porter said that she was yielding the floor to Mr. Turtletop. Is that correct?
That is.
Mr. Turtletop, please proceed.
My pleasure. Now we get to what we're going to talk about with the fence. But one quick housekeeping. Mr. Blake had referred to Exhibit TR01, the tree removal plan. I don't believe it was actually identified for the record. I just think we need to do that just as a technical thing, and then I'll get into the fence.
Are you asking him a question?
Yeah, I assume is that TR01 dated? I assume 12/8 as well, Mr. Blake.
Yes, my apologies. So tree
No, that's all
removal
right.
plan TR01, dated December 8th, 2025.
Very good. I just so the record's clear with that. So with respect to the fencing, that has been a big issue and a concern from my client, and he comes tonight with a request that any approval address the replacement of the fence and or the maintenance of the fence as it goes forward. There are currently now existing columns that are about 9 foot tall. And we understand from the needs of PSE&G for security reasons for this type of facility, they're going to need to have 8 foot high fencing that's going to go in between the columns that are going to be spaced about 3 1/4 inches apart. My client would like, Mr. Malonga would like the board to make as a condition of any approval that the new fence be made of wrought iron composed of solid pickets with a similar size to the existing fencing that exists today. That will also be done with a black finish on it. In addition, and by the way, the 2.5 spacing is to make it anti-climbing so people can't climb over the fencing in this wrought iron that's going to be installed. And then second, the support columns that are going to be installed should be in the same locations as the existing pillars are today. And to the extent possible, the foundations of the existing pillars would be reutilized by PSE&G. And then finally, my client would like the design of the and color of the brick that's utilized for the columns that are going to be replacing out there to be done with the approval of the zoning officer and or the planner as determined by this board. But this fencing does provide a historical look to the area. It has been part of the community for many years. We do know that the Historic Commission has also weighed in on this, and we believe that this will be able to satisfy the maintenance of the character of the neighborhood by doing it as we've just discussed, and would therefore ask this board, not only would we be saving the trees, but also maintaining the character going forward with this. And that's my request to Mr. Cohen. That's what my client's looking for as a condition of this approval.
So that when you talk about pillars, you're talking about the existing brick construction?
Yes, sir.
Okay.
Yes, sir.
Are those being replaced, or they're
A good portion of them will have to be, if not, the PSE&G is going to try to salvage as much as it can, but where it can't do it, they would be replacing them with a brick of a color and material to be finally approved by the board or the zoning officer and or the planner. But yes.
I couldn't hear that. Mr. Chairman, did you say my name?
Yes. Do you
Yes.
have any comments or agreement? with
Yes, I
respect-
do. So I just wanted to note that PSE&G has had substantial discussions regarding the fence. As the board is aware, we did propose a new fence in connection with our application. With respect to these proceedings, PSE&G is willing to agree to the comments as set forth by Mr. Turtletop. I would note, as we mentioned previously, the existing fence is about 6 feet in height. The new fence would be 8 feet in height, the fence portion with the pillar slightly higher, which is why we would be seeking the variance up to 9 feet, because the fence itself would be 8 and the pillar slightly higher, to match essentially the proportions as they relate to the what the existing fence looks like. And he detailed certain requirements in connection with, I guess, spacing and otherwise. I think that PSE&G would be in agreement with. And so therefore, we would agree as a condition of approval to the conditions as set forth by Mr. Turtletop regarding the new fence structure.
So that the record is clear, let me just repeat what I understand the agreement between these two parties, subject, of course, to comments from the public and subject to the board's determination, that the fence will be replaced with one constructed of wrought iron. It will be sized as is, it will be an 8-foot tall fence. The color of the fence itself will be black, not counting the pillars. The spacing will be as is presently. The pillars will be in the same locations they are now. They can be 9 feet tall. And the color of the bricks and other construction, and I'm going to make it the zoning official, subject to Ms. Gary Adams' approval, which will be binding on the parties and the board. And to the extent that the pillars need work, they will either be restored or replaced. Did I correctly express what you both folks are presenting? I'll start with you, Mr. Turtletop.
So with respect to the columns, they'll try to use the foundations and either be restored or replaced. With respect to the balusters, the wrought iron balusters, I just want to be clear that I believe the spacing will be different. They'll now be 3.25 inches apart, whereas today they are not. And that, from my understanding from PSE&G and through our discussions, is going to be necessary for them to maintain the security aspects of the no climb or the unscalable type fence that they require. But otherwise,
was there any discussion concerning plaques on the pillars?
I'm not aware. My understanding is that, and I'll leave it to Ms. Porter as to if she has further comment. My understanding, though, is that the 3.25 inches, the narrower spacing just prevents the scaling of it, and it's part of their design features.
It's an anti-climb measure that's required at all of PSE&G's facilities in connection with any new fencing installed.
Anti-climb?
So spacing of 3.25 inches, which is slightly smaller than what exists today, which would not comply with current safety requirements.
The 3.25 inches doesn't comply, or that is
It
what?
does not currently comply with our safety requirements for our sites, but the existing slats, if you will, the spacing between is slightly larger today, so it will be slightly smaller and we would only agree to fencing at that smaller ratio because it allows for the fence to be anti-climb, and so it's a safety measure.
And to be clear,
Okay,
the
but my-
3.25 does comply. Anything greater does not comply.
Correct.
So that the spacing will be 3.25 inches, period.
Correct.
Yes.
Okay.
And that's acceptable to my client and meets their standards, and that's part of why we put it in the condition.
Right, and as to the pillars, I think it's already been stated, but just to clarify, the pillars will be replaced, but the brick will be designed to match to the satisfaction of the zoning officer in terms of color and otherwise. But the existing brick on the fence, just so everybody is aware, is crumbling. The steel is rusted. It's beyond repair, which made it, any effort to restore the existing pillars themselves very difficult. However, due to concerns raised, PSE&G had previously discussed with Mr. Turtletop that it would be, to every extent possible, willing to reutilize the existing foundation, so in the same location, so as to prevent any further disturbance in terms of trees within that area or otherwise.
Just so I'm clear, is there going to be an attempt to restore, or will we simply be replacing them on the existing foundations?
It would be a replacement on existing foundations with the new
Okay.
support columns.
And that is what the interested party and public service are presenting to the board as their joint proposal, so to speak.
It's our proposal. I'm sorry. Yeah, it's Mr. Mullinger's proposal, which is not being objected to by PSE&G.
Correct.
With respect to the settlement that you've reached, other than Mr. Malanga and public service, are there any other parties to that agreement?
In terms of parties to the agreement, no, but it is done with the blessings of Mrs. Malanga and our Green West Orange.
I understand that there's a confidentiality provision, so I'm not going to request that a copy be filed with the board. I'll pay honor and respect to what the parties have agreed upon, and I don't want to cause anybody to breach a confidentiality provision, especially since submitting it to the board would open it up to Oprah discovery, etc. Mr. Turtletop, do you have anything further you'd like to offer to the board?
I have
Other
nothing
than-
further.
Other than
nothing
your
further.
undying thanks.
Nothing further.
Order. Ms. Porter?
I have nothing further with respect to our application. I would be happy to address any comments that the board's consultants have with respect to the reports that were issued. And at this point, we're ready for public comment.
Well, first I have to go back. We have some members of the
board.
board who
Yep.
wanted to ask questions regarding the fence. So let me go back to the beginning. Mr. DeBovi, any questions with respect to the agreement between these parties on the fence?
No questions from me. Thank you.
Thank you. Dr. Benzvi,
No questions. Thank you.
Mr. Dannemiller,
No.
Mr. Sussman. Mark?
No questions, Mr. Chairman.
Thank you. Mr. Schwarzbaum?
Yes. So given that this is public service, public utility, and typically on a private development, the owners would be incurring the additional cost. Can you discuss what the implications are in the increased cost and how that's going to be paid? Who does that?
Not a proper question, sir.
What?
Please, that's not a proper question. We're talking about the zoning implications and not the economics. Do you have a question regarding the understanding reached between these parties? Fence itself.
What was were well, okay, I do. Were there any discuss? This is really to Mr. Turtletaub then. So is it your client's perspective that the adjacent property should have maintained its historical look?
In terms of the design of the fence, yes, my client believes that the historical character of that fencing and the columns should be maintained as best as possible. So that was clearly one of his concerns from the outset and maintained throughout, which is why he's making this request for a condition.
But the adjacent property was developed recently. So I
Oh,
guess
I'm sorry, you're talking about the adjacent property, not the PSC&G?
what I'm asking a question is in relation to, and this may be a global question, but it's we're saying one piece of property versus an adjacent piece of property. So should we be applying throughout the township that no new designs can be put in because we need to maintain historical looks?
No, we are not bound by any determination on this project with other projects. There's no res judicata to properties that are not before us. So we make our decisions on a case-by-case basis. Do you have any questions regarding the fence itself?
What led to the compromise with PSE&G?
An understanding of the reality of what the condition is of the existing fencing and the desire, their security features and the type of materials that would try to bring back the character that has existed there for probably, I believe, over a century. Which is really what it is. I don't know what the properties that you're talking about next door. I'm sorry, when I thought you asked the question, you were talking about this property. But the idea was to try to maintain as close as possible to what exists there today. It is being redone, so it is going to have a newer look, but to maintain the historical character as this corner's existed for many decades.
And you represent two individuals?
I represent Mr. Malonga.
One individual?
Yes.
Be interested in hearing what other public members have to say.
And they will be given that opportunity. Any other questions regarding the fence, Mr. Schwarzbaum?
No.
Thank you. Ms. Miller?
Yes, referring to the HPC memo from November 14th, they've weighed in on this. I believe that the HPC should be involved in picking out the materials. This is what they do. They're experts in this. There's a very specific criteria for even becoming a member of the HPC. I would hope that they be part of the process, not just the zoning official who I don't believe has training in historic properties.
So with respect to that particular comment, we did review that memo. One of the concerns is that memo relied upon a study that was done 12 years ago. The site and the fence are not within a historic district, and so therefore it would be PSE&G's position that the Historic Preservation Committee does not have jurisdiction with respect to this application because there is no specific designation, landmark, or other status protecting the site as being a quote-unquote historic site, other than the fact that it is an older site, which is, however, in light of the concerns that were raised by the public with regard to this fence, and based on our discussions, we were willing to agree in terms of the design and look of the fence to the materials or otherwise as laid out by Mr. Turteltaub.
Thank you, Ms. Porter. I do understand that. I've read about it extensively. There is a narrative that's been going on about that property for a long time. It is recognized as somewhat historic, even though it doesn't have the designation. My request would be that since we have township volunteers who are well-versed in maintaining the look of historic properties, that the Historic Preservation Commission be help with the picking out of the materials.
So the question then, Ms. Porter and Mr. Turtletop, will you agree to a condition that the proposed design be referred to the Historic Preservation Commission for their input?
I would have to discuss that with my client. That is not something at this time I'm prepared to agree to as part of the record, because of the fact that that committee does not have jurisdiction with respect to this application.
So, Ms. Miller, you can make your request for a condition to that effect, and the board will determine whether or not it wishes to impose that condition on.
Thank you. Thank you, Ms. Porter, and thank you, Chairman.
Mr. Cohen.
Yes, I have a question about the metal bars and whether Mr. Turtletop and Ms. Porter might be interested in from the ground to the first bar, if that could be, let's say, 8 inches. So little animals could go in and out, and it wouldn't really affect the security aspects because it would still be unclimbable for a person. It would just be from the ground to the first bar, 8 inches. Would that be a consideration you guys might consider just for the little squirrel, a chipmunk, a cat, just so they don't feel as if this whole area is walled off for them? Thank you.
Thank you, Mr. Cohen. Anything else, Mr. Cohen?
That's it.
Thank you. Mr. Scott?
No
questions.
I asked the question. I asked the question for Ms. Porter and Mr. Turtletop. They'd be interested in that as a stipulation. If they're concerned about it, that the animals can't get in. It's 2.5, 2.25 inches.
The question really is whether or not they'll agree that the lower rung of the fence be 8 inches above the ground.
I would defer to Ms. Porter. I think those are something her client would have to know, and whether it gives her the same type of protection she needs.
Right, traditionally, the slats and the spacing is designed to be from the base to the top of the fence. And again, it's an anti-climb, anti-scale measure. I can certainly confer with my client and see if it's something that they're willing to consider.
Or even smaller, make sure, a little person couldn't, I guess, dig and get under. So I understand that concern, but otherwise 3.25 might be, something that interferes with the wildlife of the area. So I really would consider, I'd appreciate if you consider making the first rung a little bigger than 3.25.
Your request is being referred back to the client. Anything else, Mr. Cohen?
That's it. Thank you.
Thank you. Mr. Scott?
Thank you. I want to first thank
This is questions, Mr. Scott.
Oh, okay. Well, very well. No questions. I wanted to, I'll thank them later.
You can do that, certainly. Thank you. And I have no questions with respect to the fence. I know that the applicant and Mr. Malanga have worked many hours. Just, Mr. Turtletop, could you get the sample of the fence out of Ms. Chandler's office so she doesn't keep banging into it? It's causing some pain.
I'm not following it. I'm sorry.
Well, an example of a proposed fence was left in the office.
Oh, you mean? Oh, okay.
A form of material of the Ameristar
I'm sorry.
fence
I'm
was
sorry. Oh, I'm
provided
sorry.
to the board. Certainly, PSCNG we can remove that.
Thank you.
If I
like
may,
said,
on the issue of the zoning officer for this historic commission, and again, I know Ms. Porter has to go back to potentially talk to her client, but the zoning officer, if put into the zoning officer's hands, ultimately with a final decision, what resources the zoning officer uses, they can use. I mean, I understand your concern with Miller. I'm not sure if that would take care of it, but the zoning officer does not have to work in a vacuum in terms of coming to a conclusion. Just a thought there.
And let's wait and see whether or not the Historic Commission is here tonight to make any requests or any presentations.
Okay.
Ms. Porter, do you have anything further?
I do not.
So we can state that the applicant rests,
Yes.
and the same for you, Mr. Turtledown?
Yes.
Okay, so this application has now reached the point where we can open it up to public discussion. And let me iterate what I said before, and that is the fact that Mr. Turtletop's client and Public Service have an understanding is not binding on other members of the public who are not involved in that settlement. You are free to make whatever comments you want to make. You're free to offer testimony, both in favor of or in opposition to this application. You are not limited in any way, shape, or form by this settlement. And I encourage you, if you have anything you'd like to present to the board, to do so when we open the floor, which is right now. Mr. Fagan? will
Yes,
recognize-
Mr. Chairman, we have,
And if you wish to be heard, please raise your hand so that Mr. Fagan can recognize you and admit you to the meeting. You will be sworn under oath to provide whatever testimony or evidence you wish, with the understanding that you are subject to cross-examination. Kindly raise your hand if you would like to be heard.
Sally Malanga, welcome to the meeting. Please state your name and address for the record.
Good evening, Sally Malanga, Ridge Road.
I'm sorry, Ms. Malanga, you're a member of Our Green West Orange, which is
Correct.
part of the settlement. So you cannot be heard.
Okay, I was going to say something nice about the whole process.
I'm sure you were, and I'd love to let you say as many nice things as you want, but the rules are the rule.
Very well.
Mr. Fagan, next hand up.
As Mr. Chairman has indicated, any member of the public wishing to comment, please raise your hand at this time. Mr. Chairman, there are no hands raised.
Interesting. Okay, then the public comment portion of the hearing on this application is closed. I will bear the laboring oar and offer a resolution that the application of Public Service Electric and Gas Company under ZB 24-06 be approved. And the approval would be for preliminary and final site plan approval for the grant of the D2 variance for expansion of a non-conforming use. And with that respect to that, I accept the testimony of Public Services Planning Consultant with regard to the fact that this is deemed to be an inherently beneficial use, which in and of itself satisfies the positive criteria required for the grant of such a variance, although there are other reasons that have been stated, and I will get to those in a bit. So there's a D2 variance. There's also a D6 variance for the height regarding the lightning masts as set forth in the application. The front and side yard setback variances, the fence height, and the lot coverage variances are included in the grant of the variances. There's a condition that I have in my notes. Ms. Porter, you can respond to this, but my notes reflect that the applicant has agreed that no active construction will take place other than during normal business hours and limited to no more than 10 people at a time. With respect to the fence, the pillars are approved at a height of 9 feet. 6 feet is the limit on fences. The pillars can be 9 feet high, and the fence itself can be 8 feet high. The stipulations of Mr. Turtletab and Ms. Porter with respect to the fence, that it be made of wrought iron, that spacing between the slats be no greater than 3.25 inches, that the color of the wrought iron be black, that the pillars will be the brick pillars will be in the same locations that they are now, constructed on the existing foundations to the extent that those foundations will support the fence. The color of the bricks and aesthetics are subject to the reasonable approval of the zoning officer, who is free to consult with whomever she wishes to consult. I note, Ms. Miller, that while I appreciate your recommendation regarding the Historic Preservation Commission, they waited almost a year to submit their comments to the board. They have not appeared here tonight in an effort to have whatever they've written be imposed. And I agree with Ms. Porter that unfortunately, this is not a historic site. However, the applicant has made it clear that they are going to maintain the historic nature with respect to the fence and the pillars. And I respect your opinion, and I'm not going to add it as a condition. I mentioned the foundation as is. Just see, what other conditions I have here, if any. Most of the conditions that I had in my notes were resolved by the revised plans submitted and placed into evidence tonight, and the agreement reached and public service. Bear with me. There's the I call it a subterranean drainage system, not an underground, but that has made a lot of revisions, which have found their way into the plans. So there is no conditions in that regard. Mr. Hess has already opined that the green requirements are not applicable. The application complies with the requirements of the stormwater regulations. The forester has opined that the application satisfies the requirement of the new tree removal ordinance. The resolution should reflect that the testimony of Noreen Moreno, the planner for the applicant, was credible. It did not contain net opinions, but she did explain each of her opinions in support of the variances. As I said a short time ago, she opined, and I agree, that this is an inherently beneficial use. The facility will benefit West Orange and surrounding communities. It's not limited to West Orange. However, it will provide the electric service that we need here in our community, hopefully for another 100 years into the future. The additional special reasons testified to by Ms. Moreno include that this application supports public health and welfare. It provides energy resources which are cited in the various ordinances. This property has been utilized for this use since 1928, so that it is well suited to the application. The electricity reliability will be provided and to benefit the health safety of the community. The negative criteria have been satisfied in that the benefits outweigh the detriments based on the reasoning set forth by Ms. Moreno in her testimony. This application serves the public. It produces very little additional traffic. As I said, the tree ordinance has been satisfied, and the application has created minimal impacts if it's constructed. That's my motion. Is there a second?
Vice Chair seconds.
Seconded by Board Member Scott. Ms. Chandler, please call the roll.
Mr. Cohen,
No, I vote no because of the 3.25 inch first rung. I think it's bad for animals and there was no consideration of it.
okay. Ms. Miller,
Yes.
Mr. Schwarzbaum,
Yes.
Mr. Scott,
Yes.
Mr. Sussman,
Yes.
Mr. Miller,
Yes.
Chairperson Neuer.
Yes. Ms. Porter, Mr. Turtletaub, I would be remiss if I didn't comment, and I know, Mr. Scott, I know you want to say a few words too, so I will recognize you if you still have some comments you'd like to make.
Absolutely. Thank you. I just wanted to thank PSE&G's representative, Ms. Porter, and Mr. Malenga and Mr. Turtletaub for their work. You guys have been at this for a year, and this was a lot. And I really, this is critical infrastructure, as we said at the very beginning. It's very important. And I really want to thank you, Ms. Porter, for being willing to listen and to work with some of this town's leading advocates, Mrs. Malenga and Mr. Malenga. They're leading advocates in town, and they put a lot out and they give a lot to the town, and they are not expecting anything back in way of finance. So I really want to thank the two of them, and I want to thank you for working diligently with them. Thank you, Mr. Turtletaub.
Thank you, Mr. Scott. And I have worked hand in glove with Ms. Porter and Mr. Turtletaub, and if it were less credible counsel, we wouldn't have allowed this matter to go on as far as it has. However, they were able to convince me of their diligence and their very, very hard work. This was not an easy one. I'd like to present it as an example in my negotiating class at the Rutgers Law School. Maybe one or both of you will come and visit and be a guest lecturer one night. So this is an example of an interested citizen, Mr. Malenga, working closely with an applicant who's willing to listen. And this is a credit to both parties, and I thank them for all of their efforts. This matter is concluded. Ms. Porter, we'll try to have a resolution, Mr. Fisher, for the January meeting. This is not an easy one, so we may not get there in January, but I hope we do. But with there's nothing further that needs to be done. Thank you all very much.
We thank the board as well. Thank you.
Thank you so much.
This matter is concluded. Ms. Triolo. Let me find your application here.
Yes.
Bear with me.
Yes, I am here.
Okay, we are dealing with the next application. Let's see how far we can get. As you well know, Ms. Triolo, we stop at midnight, 11 o'clock. This is application ZB 24-15, Waystone Realty LLC for property at 42 Eagle Ridge Way. Please place your appearance on the record.
Thank you, Mr. Chairman. Priscilla Triolo from the law firm of Bittiger, Elias Triolo and Deal on behalf of Waystone Realty LLC. This is a continuation of the hearing that we had started on September 4th, 2025. May I proceed, Mr. Chairman?
Please do. And yes, that I have September 4th, 2025 also.
Okay, this is just to recall for the board, it's an application for a single-family home with a stable and an arena, which are interconnected due to the intended occupant of the premises. The application was filed on October 21st, 2024. We attended a site plan advisory board meeting on February 11th, 2025. We had our first hearing on September 4th, 2025. All of the extensions that were had from the filing until commencement and tonight's hearing were with the consent of the applicant, and the board waived all requirements for additional publication and notification. Previously on September 4th, you heard the testimony of Richard Cohen, Deborah Serbone Todd, who is an equestrian site planner, and Karen Brittle, who is the director of therapeutic writing at Centenary College. This evening, we have 4 witnesses. I'd like to recall Richard Cohen for about 2 minutes. Shauna Latinsis in equine management, Jesse Coakley from Collier's, the site engineer, and last, Joseph Burgess as our planner. And with the board's permission, I'd like to recall Mr. Cohen for a very, very brief information for the board. I believe he is still considered to be under oath unless the board wants to administer a new oath to him.
It's been too many months. I'll ask Mr. Fisher to please swear him under oath. I see Mr. Cohen has raised his right hand.
Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, you're under oath.
Thank you. So I'm going to share my screen and be very quickly. Good evening, everybody. So,
Welcome back, Mr. Cohen.
thank you. Okay, so in response to the last hearing, there was some testimony. There was a question, I believe, from one of the board members regarding the possible spontaneous combustion of the proposed composting system that we're using instead of trucking manure away. I reached out to Peter Moon, who's the founder of the company and a licensed PE out in Washington State. And in response to my inquiry, he provided me with this letter, which was uploaded, given to Ms. Chandler on December 5th and uploaded, which says in the 1800 systems that he's designed since 1996, he has had no reports of spontaneous combustion. In addition, there was another question regarding how much compost would the system generate if we had 4 horses at the site, and his calculations said there'd be 76 cubic yards of compost in a year, which would be enough to cover 2.2 acres. And the site is over 3 acres, and I live with my wife and son currently next door at 40 Eagle Ridge Way, which is 2 acres. My other son lives across at 41 with another 2 acres. So we would have more than enough use of the compost. The point being that the compost will either be given away or used on site, and it's not going to be trucked out, and we're not going to have any manure being trucked out. And this compost system should address those concerns. So that's why I wanted to get back on. And there was also a link provided to a sample system that any of the board members were free to, or anybody else, the public were free to look at to see this proposed system in operation. I believe it was in Oregon.
I thank you. I have no further questions for Mr. Cohen.
Taylor, I show that the last exhibit was A5. Is that consistent with your notes?
Yes.
Okay, so Ms. Triolo, I'm going to mark this as exhibit A6 for identification. I am telling you now that I will not admit it into evidence because it has not been testified to under oath by the author of the letter. However, it will be part of the file, and the members of the board can give it as much weight as they deem appropriate. Please continue.
Thank you. I would like to call, I don't know if
Hold
the
on.
board has any questions for Mr. Cohen, because I'm done.
Okay, so you're done. Let me just,
Yes, that letter was addressed to Waystone, so that was the reason for Mr. Cohen to introduce it.
I understand, but you do understand the necessity for authentication.
Oh, I do. I do
Mhm.
understand. I just wanted you to know that I'm done with Mr. Cohen's testimony.
Okay, Mr. Scott, any questions based upon the testimony just given to us?
Not a question, just say thank you, Mr. Cohen.
Thank you.
Mr. Cohen, you have
Yes, sir.
questions for Mr. Cohen?
Other Mr. Cohen.
Not Richard, Lawrence Cohen. Your microphone is off, Larry.
Mine?
No.
I'm sorry, guys. No questions. The letter was very self-explanatory, very good answer to the questions of the board.
Thank you. Ms. Miller,
No questions, Mr. Cohen, but thank you so much for providing it.
Thank you.
thank you. Mr. Schwarzbaum,
No questions.
Mr. Sussman,
No questions, Mr. Chairman.
thank you. Mr. Dannemiller,
No questions. Thank you.
Dr. Benz-V,
No questions. Thank you for the letter, and I also watched the short video. Thank you.
Thank you.
Mr. DeBovi,
No questions from me either. Thank you.
and I'm not going to pose any questions. Ms. Triolo, please continue.
I'd like to call my next witness, Shauna. Shauna Latinsis.
Latinchich.
Kindly spell your name for the record, Shauna.
Latincissis.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you are under oath.
With no,
Shauna.
with no disrespect, may we refer to you as Shauna?
Absolutely. It's much easier.
Okay.
I apologize. I'm the worst with problem names.
Oh, are you
Can
kidding?
can you please give the board the benefit of your background before we get into your testimony?
Yes, of course. So I've been a lifelong equestrian. I've been riding, training, showing horses my whole life since I was a child. My love of the animal led me to pursue a degree in equine science and management, and I graduated from Morrisville State College in Morrisville, New York, with a bachelor's in equine science and management in 2012. And while I was there, I worked at various facilities, gaining experience with different genres of horsemanship. I worked with show horses, breeding stock, foals, and both thoroughbred and standardbred racehorses. And I know that the experience that I gained during my collegiate career led directly to the Chapeau family of Neshannock Station, New Jersey, offering me a position as showgroom on their shadow farm before I'd even graduated college. And it's kind of a big deal. It's kind of cool. They are Frank and Mary Chapeau. They both represented the United States in multiple Olympic Games. Mary was actually the very first woman to represent the United States in the Olympics. She's also the first woman to win a Grand Prix on U.S. soil, and that Grand Prix, or I'm sorry, she was the first woman to win a Grand Prix ever, and it happened to also be the first Grand Prix on U.S. soil. And after Frank's riding career was over, he served as the chef d'équipe, which is the coach for the United States equestrian team, for about 20 years. So I highlight that to let you know that, my professional career started with people who knew what they were doing. They were doing it right. And, while I was there, I learned a lot about how to manage a farm of approximately 30 horses that were competing at the top level of the sport and maintaining meticulous standards that are accepted or expected of an Olympian while doing it. And this set me up pretty well to transition into the role of barn manager at North Star Sport Horse in East Aurora, New York. And this is a position which I held for 11 years. I did pretty much everything there. Oversaw all the day-to-day operations. We had approximately 50 horses, from broodmares, foals, young stock, all the way up to horses competing at the 5-star FEI international competition level. And a lot of my duties included creating nutrition programs for each horse, maintaining healthcare standards, scheduling vets, farriers, chiropractors, and any other professionals that the horses might need to come in, keeping records, maintaining inventory of feed, supplies, hay, bedding, and of course the daily hands-on care of the horses, including mucking stalls. I made sure the horses all got handled every day, ridden every day. I created the program to break out the young horses. That's a term we use when you begin a horse in its training.
Excuse me, 1 minute, Shona. Ms.
Yes.
Triolo, are you offering Shona as an expert?
As a barn manager in the field of barn management, to understand what a barn manager does and to support the application to have the barn manager be in the facility itself.
Well, based upon the credentials she's presented, I will recognize her as an expert in the field of equine sciences.
Thank you. I just wanted to add one thing and just have her confirm you testified as an expert in the field of barn management in Upper Saddle River. Is that correct? Upper Saddle River, New Jersey?
Yes, I did. I tested, excuse me. I testified in 2019 for Patriot Farm in Upper Saddle River. It was a similar project, a private barn that a family was building for their own use, and they wanted, a manager's apartment included in the barn. And my testimony on that project actually is what set the standard for the state statute.
Thank you. The state statute regarding this was attached to the planner's report that was given to the board by Nishawan when they did their examination. Shona, please explain your employment by Waystone Realty and what your understanding and opinion is, your professional opinion with regard to the barn manager being located in an apartment above the stable, which we are requesting as part of this application.
Of course.
And now I sit down.
I was hired by Waystone. I'm sorry, I have to apologize for my voice. I have a cold. I was hired by Waystone in July of 2025 to act as an expert witness and provide testimony as to why on-site housing for staff on a horse farm is necessary. I have spoken to Mr. Cohen. I have reviewed the proposed plans as well as the written narrative that he made up. And in my professional opinion, I do believe that the facility is laid out very well and will facilitate efficiency, safety, and of course, Jordan's enjoyment of the horses and the success of his therapy and his athletic pursuits. It's notable that the riding arena is connected to the barn. Of course, the first thing that comes to mind is safety. New Jersey's in the Northeast. We get snow, we get ice. If it's connected, you don't have to worry about the elements posing a slip and fall possibility for horses or riders. As you can imagine, if a horse goes down, they go down hard. And the same applies to to Jordan's residence being attached as well. It eliminates the need for snow clearing and having to deal with the elements as he travels, back and forth between the barn and his dwelling. Elopement is also a concern with him, being that he is on the spectrum, and having everything under one roof and easy to navigate, easy to get back and forth is going to be something that's going to eliminate that possibility and bring a lot of peace of mind to his family. As far as the manager's apartment upstairs, that is top. That is the one thing you definitely want to have when you're building a barn. It is essential. It is industry standard. The thing is, people think of horses as these big, powerful, strong, athletic creatures, but they're remarkably fragile. So a horse's leg bones are like roughly the same diameter as a person's, and they're carrying around 10 times the weight, and they can certainly run way faster and jump way higher than we do. So you can imagine that injury to the legs is common. Some leg injuries can be obvious. More often they're not. More often they start as something very small, something that could be easily overlooked if someone wasn't looking for it. But someone with an astute eye who's got eyes on the horses every day and is checking their legs every day, multiple times a day, which is something that the manager would be doing, would find those injuries and be able to attend to them before they become a serious problem. Another way that horses are fragile and need babysitting, so to speak, the term colic, it's a broad term. It covers more or less any gastrointestinal upset that a horse may have. The way that a horse's digestive system works, they have several one-way valves. So once food, water, air, anything gets swallowed, they can't burp and they can't vomit. So the only way for everything to come out is out the back. So if you think about, if you have the stomach flu and, you're horribly sick, you vomit and then you're better. Well, a horse can't do that. So if a horse gets an upset stomach in that way, it's a serious emergency and it needs to be attended to. The other thing with their gastrointestinal system, it's a really poor design, actually. The only thing that keeps all their intestines in place is the other intestines being in the right place. So if something falls out of place, it creates a domino effect, and that can create an intestinal torsion, which can only be fixed surgically. Now, some colics are not a huge, emergency deal. For instance, actually just this past Thanksgiving, I had a horse act colicky, and I did not want to call the vet on Thanksgiving and be that person to take him away from the family. So I observed the horse, monitored his symptoms. I treated him with some medication, and I determined that it was a mild gas colic. Basically, he had to pass gas, and he was uncomfortable in the meantime. Now, had he not improved in a reasonable amount of time, I would have called the vet, and I would have been hooking up the trailer to bring the horse to Cornell University, which is our closest surgical hospital.
Now you're talking about all of the issues that, as a barn manager, you would be observing of the horses. Is that correct?
Correct. Yes.
And is that part of the reason why it's important that the barn manager be there?
Yes.
On a daily 24-hour basis because of these situations?
Yeah, it's imperative to know each horse's personality. For instance, the horse I just spoke about on Thanksgiving, he is one of the most stoic horses I've ever met. So when he was showing signs of discomfort, I knew it was real. Other horses are wimps, and they'll act uncomfortable over the minor inconveniences. But yeah, someone who's with the horses 24/7 is going to know their personalities. They're going to know what's normal, what isn't. How much is it normal for them to eat? If they didn't eat that much, something's wrong. How much is it normal for them to drink? If they didn't drink that much, something's wrong. And it's not something that you can clock out at the end of the day, tuck them in and say, see you later. Horses do lay down to sleep. They can sleep standing up, but they do actually have to lay down to get REM sleep. And when a horse becomes cast, as the term is, it's when they lay down too close to the wall and their legs are kind of scrunched up in a way that they can't extend them to stand up properly, and they get stuck. And they can get stuck upside down. And like I said before, with the intestines only staying in place by everything else being in place, gravity is your enemy there. And if they're stuck in an upside down position for an extended amount of time, that could cause a torsion. In a worst case scenario, if someone's not there to attend to a horse that's cast, you can potentially open the barn to a dead horse in the morning. But when they're cast, they make a heck of a ruckus. They're banging against the wall, they're struggling, they're trying to get up. So someone who's living in an apartment right above the barn is going to hear that, and they can come down, assess the situation, and assist the animal.
Hold on 1 second. Ms. Triolo, we're going a little far afield. Although it's fascinating to hear about this stuff, it doesn't really impact on the issue regarding having a barn manager.
Yes, she's going to narrow down to it right now. Considering all.
Go ahead.
Considering all of your observations of horses and getting to know your horses, can you please focus down to the need for the barn manager to be on the premises in order to protect the horses and bring safety, and why that's industry standard? And is that what you do right now? So
yes,
just very quickly, he wants to get you to explain why having a barn manager in the stable is related to what you are testifying to.
All right. Yes, to clarify, I do currently fill a barn manager position. And, all the things that I just outlined are things that can go wrong. They go wrong very quickly, and they need to be attended to quickly for the safety and the health of the horses. A good barn manager is going to be a jack of all trades, essentially a veterinary staff member without the degree. Then that's actually a direct quote from my veterinarian. So they're going to be able to assess any situation which may go wrong with the horses and attend to it in a very quick manner and efficiently.
What is the industry standard for compensation to a barn manager?
So it's typical for a manager to receive a salary as well as room and board for themselves in an apartment and room and board for a personal horse.
Okay. So in your experience and understanding what you do about horses, in your professional opinion, would it be advisable to have the barn manager reside in an apartment on the second floor of the stable for this application?
Yes, absolutely. Some farms where the existing structure doesn't allow for an attached apartment to be built may have a separate house, cottage, apartment detached from the barn. But this is not preferable. This is only in the cases where the existing structure was not able to be added onto for whatever reason. Any new build is going to be having an apartment built in the barn because the horses do need someone there 24/7, keeping tabs on them, keeping eyes on them. There's also this crazy phenomenon in that people drive down the road and they see horses and they come up the driveway and they walk in your barn and they want to pet the horses, which of course is trespassing. It's a liability. Having someone on the premises to assess that situation and kindly tell folks to please vacate the premises is also another bonus.
Right. Mr. Chairman, I think that she summarized the need for the barn manager to be on site and why we propose to have an apartment above the barn. I would also like to, in response to her testimony, is also to request a waiver for having a temporary fourth horse if the board sees fit to approve having a barn manager on the premises, to allow that barn manager to have a horse in addition to the 3 that are permitted by the code, and consider everything amended in order to request the ability for that 4th horse. I have no further questions of Shauna.
I'm going to ask Mr. Dockney to be prepared to address the waiver request whether it's a waiver or a variance when we get to him. Let's go to members of the board. Mr. DeBovi, questions for the witness based on her testimony.
Thank you for your testimony. I have no questions. Thank you.
Dr. Benzvi.
Thank you. Ms. Latinchich, I have just a question because you said, I do understand the point of having the barn manager on site, but what about using, technology, cameras, monitors, things like that, if you cannot live right above the barn?
Yeah, of course, that's a common question. And the simple answer is technology fails. The power goes out. I've had birds fly into cameras and break them, and leave them inoperable. You can't rely on technology. You can't replace eyes and hands on site.
Okay, thank you. That's all I had, Mr. Chairperson.
Thank you. Mr. Miller.
No questions. Thank you.
Mr. Sussman.
No questions. Thank you.
Thank you, Mark. Mr. Schwarzbaum.
No questions.
Ms. Miller.
No questions. Thank you, though, for your testimony.
Mr. Lawrence Cohn.
I have a question to the horse expert about now there'll be 4 horses. In her professional opinion as a horse expert, is the facility size good enough for 4 horses? Is it too small? Is it the right size? How about size and for the happiness of the horses?
I'm sorry, can you repeat that? The what size?
The size of the facility,
Oh, yes, yeah. Oh, it's perfectly suitable. Yeah.
Is this a smallish size? Is it medium? Is this large? How does this fit for 4 horses?
Well, location. In North Jersey, it is pretty common, pretty standard, to be expected. Of course, if you were down in Kentucky, you see these rolling 500-acre fields. But yes, for the area of the country it's in, it is perfectly standard.
Okay, and it does make great sense to have an expert right above the horses. And I know there was like some consideration of health aspect the last hearing, and I think that was just a bunch of baloney. And
Mr. Cohen, question, please.
That's what I just want to say, that and she's the expert. She's going to live above the horses. I think that that should clear the board.
No, she will not be the barn manager here. She has a position elsewhere.
Oh, okay. I thought she was going to be there. Well,
she's testifying as an expert, independent.
Okay, I thought they were going to be hiring her. Okay, thank you.
You're welcome. Mr. Scott?
Thank you. Now the question, just concurrence with Board Member Cohen, that you've made it very clear that it is a necessity for a barn manager to be on the property. Thank you very much.
Thank you.
Sean, is barn management that you just testified to consumed within your degree of equine sciences management?
Yes, it is.
Okay, thank you very much.
That'll be the management portion of the equine science and management.
No further questions from me. Let's go to Mr. Duckney.
Yes, Mr. I don't have any questions at this time. I believe you wanted me to weigh in on whether or not the question of the number of animals would be a variance or a waiver. Is that correct?
Yes, sir.
Okay, so under 25-9.2, this falls under 25.9, which is supplemental provisions for residential districts. Your code doesn't specifically call this to be within the zoning section, nor does it call it a design standard. So I think to be conservative, it'd probably be I would interpret this to mean that the supplemental provisions are supplemental zoning provisions. So to be conservative, although I could be argued either way, to be conservative, I think it's safer to call them variances rather than design waivers, because it does deal with the standard of a building or enclosure for the housing of animals may be constructed or maintained only as accessory to the main building, and no building structure shall be used for the housing of more than 3 domestic or farm animals. So since your code doesn't, sorry, but long story short, I think it's safer to call it a variance rather than a waiver.
Just for the record, Mr. Nauer, the applicant, when we noticed and published, we actually stated in bold, shall seek such other permits, variances, waivers, and/or exceptions which may become evident during the hearing.
I'm aware of that, so my question, Ms. Triolo, does the applicant wish to amend the application to include a request for a variance to allow a fourth horse?
Yes,
I would consider that to be a minor amendment. No further notice is required based on what was in your notice, and we can continue with this application.
public.
I'm sorry,
I said, are we
Mr.
on to the public? I was asking.
you're jumping past two of my,
I'm sorry.
Mr. McNeil, any questions for the witness?
Thank you,
Ben?
Mr. Chairman. I don't have any questions, but I did want to point out, my office did not do the engineering review. I think Matrix New World may or may not have a representative here as well.
Yeah, we did.
Yeah,
I'm
questions.
Sean Savage here. I'm with Matrix. No
Okay, Sean,
questions.
but give us your camera on, please.
How you doing? Yeah, no questions to the witness.
Okay, but let's go back to Mr. Fisher. Would you administer the oath to Mr. Savage, because we did not do that at the outset?
All right, please raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, you're under oath.
And now would you like to repeat what you said, Mr. Savage?
Yeah, I have no questions.
Great, thank you. Ms. Carballo, are you still with us? I don't see her on the screen. Okay, now we will move to public questioning, members of the public. This is your opportunity to ask questions of the witness based upon her testimony presented this evening. It is not your opportunity to make statements or offer evidence. That will come at the end of the hearing. If you wish to ask a question, kindly raise your hand so that you can be recognized and admitted by Mr. Fagan.
Rachel Klein, welcome to the meeting. Please state your name and address for the record.
Hi, Rachel Klein, Howell Drive. Can you hear me?
Yep.
Yes.
Please.
My question, Shauna, would you consider having horses on a property without a barn manager akin to having children, like toddlers in a home without a babysitter?
Yes, actually, that's a very good comparison. Yes, they're like half-ton toddlers.
So any property in the town that has horses should probably then have a babysitter.
That's correct. Yeah, that's why it's the industry standard.
Thank you.
Welcome.
Anything else, Ms. Klein?
No, I'm good.
Thank you. Mr. Fagan, do we have any other questioners?
As Mr. Chairman has indicated, this is the time for members of the public to raise their hand if they have any questions for this witness. Mr. Chairman, there are no hands in the audience raised.
Fine, then the questioning from the public is at an end. Ms. Triolo,
Yes.
you've got about 15 minutes.
My next
have-
witness is Jesse Coakley from Colliers Engineering.
Hello.
If you could please swear him in.
Please raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, you're sworn.
Mr. Coakley, can you please put your qualifications on the record and state for the record if your license is current and has not been suspended?
Sure. My name is Jesse Coakley, Cokeley. I'm the engineer of record for the project with Colliers Engineering and Design. I've been in land development for over 20 years. I graduated from Manhattan College in 2005 with a Bachelor's of Science in Civil Engineering. I've been a licensed professional engineer since 2012, and my license in New Jersey is current and in good standing.
We offer him for as an expert.
Mr. Coakley, has your license ever been suspended? Thank you so much. We will accept you as an expert in the field of civil engineering as a licensed professional engineer. Ms. Triolo, witness with you.
Mr. Coakley, did you prepare the plans and the stormwater report that was submitted with this application, including any and all amendments of it?
Yes.
Can you please explain to the board the site and the stormwater system the best way you can, possibly without me leading you into areas that are important?
Sure. I can do that. I'm going to share my screen. This is the preliminary and final major site plan set that my office prepared, last revised December 3rd, 2025. It's part of the record already. I don't know if you want to label it as an exhibit, Mr. Chairman.
No. If this was the submission set, but the revision date is December what?
2025.
What day?
December 3rd.
Thank you.
Sorry about that.
Still 2025, right?
Yes, sir. Yes, sir.
Please continue it.
Sure.
It's already in the record, so it doesn't have to be given
Great.
an exhibit number.
So this is the cover sheet, 1 of 9, just situating. The site is located at 42 Eagle Ridge Way. You can see an aerial image on the left side, tax map on the right-hand side. It is identified as Block 106, Lot 24.01 on the Township of West Orange tax maps, which falls within the R1 residential zoning district. The property is a little over 3 acres in size and is presently undeveloped, although it was previously improved with a single-family home, which was recently demolished as part of this project. The site is bound by I-280 to the west and is located at the dead end of Eagle Ridge Way. Switching to sheet 2 of the plan set, which is the existing conditions and demolition plan. North is now towards the top of the page where Eagle Ridge Way is located. The general topography of the site is higher on this northwest side where Eagle Ridge Way is located and grades down towards the southeast property line and down the mountain to Llewellyn Park. This sheet, the demolition plan within our submitted site plan set, depicts the existing grades as well as the approximate location. You can see it in a dashed line here. I'll just use a highlighter to roughly outline it. But that's the rough area of the prior driveway and house that again was demolished recently as part of this project. The plan also includes the required steep slope calculations, which the Matrix New World review letters keenly caught that we have a typographical error here under the lot area for the slopes between 10 and 14.99%. This should simply say 9,754 square feet instead of 99,754 square feet. I believe one of the comments in the letter asks us to submit a plan showing those areas, and we can agree to provide that plan, no problem. But the site does comply with the steep slope ordinance. I'm going to go to the next sheet, which is the overall layout. I know we have seen this in prior testimony, but I'm going to briefly go over it again, as the proposed development consists of a connected single-family house and barn for keeping horses and the indoor arena. There is also an outdoor arena, as well as several grass paddock areas, landscape areas throughout the site, as well as driveways and pathways and walkways, to get around the site, as well as some retaining walls and fences for security and grading purposes. While the applicant is seeking a use variance, as we note, there are no variances required or requested from the bulk standards, as was identified on the zoning table on our layout plan. I'm going to switch to the grading plan here. A lot of text on this plan, but under the proposed condition, the site has been graded to mimic the existing drainage pattern and topography. So keeping the high side of the site, on the north end by Eagle Ridge Way, grading towards the south end of the property. However, through the use of grass swales, a series of drainage inlets, and permeable surfaces, combined with an underground chamber system, the site is able to comply with the township stormwater management regulations that went into effect in November of 2024. We are meeting the required peak flow reductions for the 2, 10, and 100-year storm events. There is not a quarter-acre increase in motor vehicle surface compared to the prior condition, so water quality treatment is not required. Groundwater recharge is being met through the infiltration anticipated as part of the design. Within our stormwater management report, we do include geotechnical testing, the latest round of which was conducted just before our last hearing in August, around August 25th. And Phil Scott from Matrix New World was there to witness the tests, which did provide positive infiltration and a depth to groundwater, which we are maintaining separation from. We do also have a black and white landscaping plan here. I know a colorized version was presented under prior testimony from a specialist who did help with the proposed landscaping in addition to the layout operation of the horse areas. Currently, there are trees on the northeast property lines to 40 Eagle Ridgeway, existing trees, and on the southeast property lines to 44 Eagle Ridgeway, which will be protected during construction. We're in receipt of the Forester's Review member dated December 16th, and we will agree to walk the site with the forester to identify the said trees that are close to the limit of disturbance on the property line, to identify them and place tree protection around them so as to avoid disturbance. In reviewing the site as well, there are also 6 to 8 existing trees located near the area of the southeast paddock. We're going to attempt to avoid removing those trees, and if any of them do interfere with the site layout, including the drainage facilities, we will certainly file a tree removal and replacement permit with the forester, and can also look at those trees during the site walk with the forester. I do want to mention, which was, I think, part of prior testimony from the Ms. Serbone, certain trees are toxic or ill-advised for horses due to their habits. The trees in and near the paddock area need to be examined by her as well in the presence of the town forester to, make sure those trees are appropriate and any replacement trees could be agreed upon. The proposed landscaping plan calls for 54 shade trees, 367 shrubs, and 127 perennial plantings. We recognize West Orange requirement for native plants. The rough number of trees and approximate location of the plantings shouldn't change, but the species can certainly be swapped to native, non-invasive species, so long as they are not toxic or nuisance to horses. So as a result, we're seeking a condition of approval to allow the application for a tree removal and replacement, along with the review of all landscaping to be subject to the review and consent of the forester and the project equine arborist. That pretty much concludes my direct testimony. Like I said, I am in receipt of the review letters, Priscilla, if you want me to go through those
Yes,
and
sir.
answer any specific questions or how you want to handle it.
You need to respond to the Matrix New World. I believe that you've responded sufficiently to Mr. Kipp on the tree protection. You need to respond to Matrix New World's letter of December 16th, 2025.
We're gonna have to reserve that for your next hearing date. We're running perilously close to the 11 o'clock hour, and we do need to conclude the meeting. We do have room on the February 19th agenda. How does that work for you, Ms. Triolo?
I'll make anything work as long as we can get on and not be the last 45 minutes.
Well, I appreciate your comment, but we do have a very packed set of agendas. Let me see what I can do. Let's see, just bear with me. You have an earlier docket number than Montclair Stables, so you will be heard first on February 19th. You will have at the very least the first half of the meeting till 9:30. Let's see if you're close to finishing, then we'll finish it.
Do you have any special meetings available? Or no? I lost track of your calendar when you were talking about special meetings.
I know, I think I said the 19th. Well, it's tough to schedule 2 special meetings in 1 month. Let's see how far we can get on February 19th. And if necessary, we'll try for a special in February for you.
Well, I only have Mr. Burgess after Mr. Coakley, and then my witnesses are complete at that point in time.
Will that be the real Joe Burgess?
That is Joe Burgess.
Nice
How are
to
you?
see you. Nice to see you again, Joe.
Same here.
So
Mr. Burgess understands how to get things done on an expedited basis. So let's put you on February 19th. And hopefully we'll get you finished by halftime. If not, we'll finish it.
I thank you very much. I wish all of you happy holidays and a happy new year. Thank you for your kind attention to my witnesses and understanding, particularly Shauna's testimony with regard to the care of the horses. Appreciate all of you responding.
Shona, is there any truth to the rumor that horses cannot eat peanut butter?
I don't know about that one.
Okay, try and find out.
They love watermelon.
Members of the public, this application is now being carried to the meeting of February 19th, 2025. No further.
2026.
2026, thank you. This, it says 2025 on my list. Sorry. February 19th, 2026, it will be the first application heard that evening. No further notice is required. This is the only notice that you will be given. Ms. Triola, do you extend the statutory time to complete the application until February 28th?
Until February 20th. Did you say February 19th?
No, the meeting is February 19th, but I always give a fudge factor.
Okay, I got confused for a second. Absolutely, we consent to, we do not object to the extension.
Thank you so much.
And just put on the record that no further publication and notice is required.
I just did that.
Okay, well, with my consent.
Ms.
We're
Chandler, was there something you wanted to say?
Okay.
Thank you, Ms. Triolo. That was a very efficient presentation. Ladies and gentlemen, we are finished with tonight's meeting and we will resume on January 15, 2026, which will be our reorganization meeting, and then go into the applications that will be listed. Thank you all for your participation tonight. We got a lot accomplished. This meeting is adjourned.
Mr. Chairman.
Thank you all. Good
Good
night,
night,
everyone.
everyone.